Judge Richard Leon didn't even look at Jasmine Crockett when he cut her off, mocked her argument, and signaled the courtroom to move on. But seconds later, she stepped forward, dropped her folder on the table, and exposed what the state tried to hide. The judge went silent. The government's lawyers turned pale, and the entire hearing spiraled into a legal meltdown that changed voting rights forever. The federal courtroom snapped to attention the moment the bailiff's voice rang out. "All rise." Conversations died mid-sentence. When Judge Richard Leon stepped through the side door, the temperature in the room seemed to drop. People didn't whisper his nickname out loud, but everyone knew it. The Hammer. He had a reputation for crushing weak arguments and humiliating unprepared lawyers. Across the aisle, the mood was completely different. There was no army of lawyers, no stack of binders, just Jasmine Crockett standing alone at her table, waiting quietly. Judge Leon's eyes drifted in her direction. He paused for a split second longer than usual. The judge cleared his throat. "Let's not waste time today," he said, his voice firm and clipped. "We are here to hear arguments on the state's voter ID law." The government lawyers straightened in their seats, ready to take control. Cameras clicked softly, pens hovered over notepads. Jasmine didn't react. She didn't rush. She didn't look nervous. She simply stepped forward, calm and steady, and placed a single manila folder on the table in front of her. Judge Leon shifted in his chair and glanced down at the docket. His posture said he was ready to move fast. He expected opening statements, standard arguments, and predictable positions. Crockett took one slow breath, stepped closer to the podium, and lifted her eyes to meet his. She didn't ease into it. She unfolded the map in one sharp motion and snapped it open on the screen like she was laying evidence on a table. Bright red blocks spread across the state, cutting through neighborhoods like warning signs, while tiny blue dots sat far apart, scattered and lonely. "This," she said, tapping the screen with her finger, "is what your neutral law looks like in real life." A low murmur rolled through the courtroom. "You didn't build access. You built distance. You didn't create order. You created obstacles." Judge Leon slowly rose from his chair, drawn toward the screen, his boots echoing lightly against the floor as he moved closer. One of the state's lawyers jumped up halfway from his seat. "Your Honor, this presentation is emotional manipulation." Crockett cut in before the judge even turned. "What's emotional is telling working families to ride buses for 6 hours just to earn the right to vote." The attorney froze. Leon raised a hand without looking back. "Sit down." The command landed hard, and the room went silent again. Crockett didn't slow down. "In these red zones," she continued, pointing sharply, "people travel up to 175 miles round trip for a government ID. That's gas money they don't have. That's wages they lose. That's childcare they can't afford." She turned slightly toward the bench. "You want to call that inconvenience? Then let's be honest and say what it really is. It's pressure. It's exhaustion. It's calculated frustration." She took a step closer to the screen. "And don't pretend this happened by accident. These DMV offices were closed after lawmakers saw the demographic maps. Hours were cut after they saw who lived here." Her voice tightened. "That's not coincidence. That's targeting." Cameras clicked rapidly now, reporters leaning forward, pens moving faster. She gestured toward the gallery without softening her tone. "Ms. Clara Watkins is 76 years old. She stood in line for 2 hours. She was told her ID wasn't good enough. She told me they didn't just turn me away, they erased me." Crockett paused, letting the words hang in the air. Then she pointed to the man standing quietly in the back. "That veteran served this country, wore its uniform, paid into its system, and was told his identification wasn't acceptable. If that's fraud prevention, then it's the strangest definition of patriotism I've ever seen." She turned back to Judge Leon, eyes steady, voice firm. "Your Honor, if this law were truly about protecting elections, it would make voting easier and safer at the same time. Instead, it makes voting harder for the same communities, over and over again." The judge stared at the screen one more time, then slowly turned toward her. His voice was low, but it cut through the room. "This doesn't look accidental," he said. "This looks deliberate." Judge Leon straightened in his chair, folded his hands together, and leaned forward. The room felt tighter, heavier, like the air itself was being pulled toward the bench. "Let's test your argument, Ms. Crockett," he said calmly. "Suppose the state assigns polling locations based on the last 4 digits of a person's social security number. On paper, that system doesn't mention race, income, or geography. But in practice, it forces certain communities to travel twice as far to vote. There's no written intent to discriminate. Would that violate the Constitution?" The question landed hard. A few lawyers in the room shifted in their seats. This was one of Judge Leon's favorite weapons. Clean hypotheticals designed to corner attorneys into bad answers. Crockett didn't answer right away. She lifted her eyes, took a slow breath, and then spoke evenly. "Your Honor, that scenario has already been answered by the courts." She stepped slightly closer to the podium. "In Gamillion versus Lightfoot, a city redrew its boundaries using neutral language. No racial terms, no explicit targeting. And yet, 99% of black voters were pushed out. The Supreme Court didn't ask what the law claimed to do. It looked at what the law actually did." She paused. "And it struck it down." A ripple moved through the gallery. Judge Leon's eyebrows lifted just slightly. He tried again. "But what if the state can prove there was no malicious intent? What if lawmakers simply made a poor policy decision?" Crockett's tone sharpened. "Then the question becomes this: how many people must lose access to their rights before we stop calling it a mistake?" She turned her palm upward. "If a bridge collapses every time certain families cross it, do we call that bad engineering, or do we shut the bridge down?" A few quiet gasps followed. The judge sat back, studying her. Leon wasn't finished. "So you're saying outcomes matter more than motive?" Crockett didn't hesitate. "I'm saying the Constitution protects people, not excuses. If a law consistently harms one group while benefiting another, the burden shifts to the state to justify that harm. And in this case, they can't." Her voice lowered, slower now, more controlled. "Because the evidence shows they didn't just ignore the impact, they anticipated it." Then she turned the table. "May I ask the court a question, Your Honor?" The room stiffened. Leon hesitated, then nodded. Crockett looked directly at him. "If the state knows a policy will block tens of thousands of lawful voters and proceeds anyway, at what point does tolerance become permission?" The courtroom went completely still. Judge Leon stared at her without speaking. Jasmine Crockett didn't celebrate the silence. She used it. She reached back to her table, opened her folder, and pulled out a thin stack of printed pages. "Your Honor," she said evenly, "we've been talking about impact. Now let's talk about intent." A low murmur swept the room. She walked forward and placed copies on the clerk's desk, then turned toward the state's table. "These are internal emails between the State Election Commission and the consulting firm that helped design this ID policy." One of the government lawyers stiffened. Another leaned toward his colleague and whispered something urgently. The color drained from the lead attorney's face as Crockett continued. "Page 3. Second paragraph. I'd like everyone to read it." Judge Leon picked up the document and scanned the lines. His eyes slowed. His jaw tightened. Crockett didn't soften her tone. The consultant writes, and I quote, "The advantage of using these criteria is that they disproportionately affect demographic group A while preserving plausible deniability, since race is never explicitly referenced." The gallery erupted into hushed shock. A staffer on the state side leaned back and whispered, "Oh no," barely loud enough to hear. Another attorney started flipping pages frantically, hands shaking, trying to find the same line. Cameras clicked nonstop now, reporters exchanging looks like they had just witnessed a major break. Crockett turned sharply toward the government table. Counsel, are you denying the authenticity of this email? The lead attorney hesitated. We would need time to verify. Crockett cut him off. It's your client's server domain, your metadata stamp, your document production label. You handed this over in discovery. She raised her voice slightly. So I'll ask again. Is this real? The attorney swallowed hard. It appears to be, he muttered. Judge Leon looked up immediately. On the record, he said firmly. Answer the question. The lawyer nodded stiffly. Yes, Your Honor, it appears authentic. The room buzzed like a live wire. Crockett didn't let the moment slip. So now we are no longer talking about neutral policy design, she said, her voice cutting cleanly through the noise. We are talking about strategy, planning, targeting. This wasn't sloppy lawmaking. This was surgical. She stepped closer to the bench. They didn't just predict harm. They designed it. And then they hid it behind legal language so they could pretend it never happened. Judge Leon read the email again, slower this time, then looked up with visible anger in his eyes. He set the papers down carefully and spoke in a low, controlled voice that filled the courtroom. This is not accidental, he said. This is engineered. Jasmine Crockett didn't wait for the noise in the room to die down. She lifted a sealed envelope from her folder and held it up so everyone could see it. Your Honor, she said calmly, there is one final document this court needs to see. We obtained it late last night. The room tightened instantly. Judge Leon raised an eyebrow. Proceed. Crockett walked to the clerk's desk and handed over the envelope without ceremony. The clerk broke the seal. The soft rip of paper sounded far louder than it should have in the packed courtroom. Heads turned. Reporters leaned forward. Even the state's legal team froze in place. The clerk carried the document to the bench. Judge Leon unfolded it slowly, deliberately, scanning the first page. His eyes narrowed. He stopped reading for a moment, then started again, this time more carefully. The courtroom was so quiet that the shuffle of paper echoed off the walls. Crockett stood motionless, watching him read. When he reached the middle of the report, his posture shifted. His shoulders tightened. His expression hardened. She broke the silence. That memo comes from the state's own election security division, she said firmly. It is dated 2 weeks before this ID law was announced, not years before. Not after public backlash. 2 weeks before. She took a step forward. And it states, in plain language, that there is no meaningful evidence of in-person voter impersonation. None. Zero. Gasps spread through the gallery. A woman in the press row quietly mouthed, "Wow." On the government side, one attorney rubbed his forehead. Another stared straight ahead, jaw clenched. Crockett didn't slow down. Now let's compare that with what the state told the public. She turned toward the bench. They said this law was necessary to stop widespread fraud. They used fear, they used headlines, they told voters this was about protecting democracy. Her voice sharpened. But internally, their own experts said the threat didn't exist. She pointed toward the memo. So the question is simple. Why pass a law to fix a problem your own data says isn't real? She turned toward the state's table. I'd like an answer. The lead attorney stood up quickly. Your Honor, we were not aware of this document. Judge Leon cut him off instantly. That's not what I asked. His voice dropped, slow and dangerous. Your client's security team wrote this report. It contradicts your entire argument. Are you suggesting the state ignored its own findings? The lawyer hesitated. His mouth opened, then closed again. I would need to consult with my client, he said weakly. Leon leaned forward, eyes locked on him. I suggest you do that immediately. The judge looked back down at the memo, then raised his head and spoke to the room with unmistakable authority. Your entire justification just collapsed. The state's lead attorney stood up slowly, like someone walking into a fight he already knew he was losing. His confidence from earlier was gone. He adjusted his tie, cleared his throat, and began speaking in a voice that sounded thinner than before. Your Honor, while opposing counsel has presented dramatic material, the state maintains that the intent of this legislation was to preserve election integrity. He didn't get to finish. Judge Leon raised a hand. Counsel, answer the question I asked you, he said flatly. How do you defend a fraud prevention law when your own security division says the fraud does not exist? The attorney froze. He glanced sideways at his team. A junior associate quickly slid a note toward him. He skimmed it, swallowed, and tried again. The state believes the broader risk environment still justifies proactive measures. Leon cut him off again. Belief is not evidence, he snapped. I asked for facts. The attorney's face tightened. Another assistant leaned forward and quietly pushed a new document across the table. He flipped pages faster now, eyes darting, hands slightly shaking. The courtroom could feel it. The momentum was gone. The control was gone. What remained was damage control. Crockett rose for her rebuttal without drama. She didn't raise her voice. She didn't gesture wildly. She simply spoke. Your Honor, this case isn't complicated anymore. The state claimed fraud. Their own experts disproved it. They claimed neutrality. Their own emails exposed targeting. They claimed necessity. Their own data destroyed it. She paused, letting each point land. There's nothing left to defend. The lead attorney tried once more. Even if mistakes were made, Crockett cut in, sharp and precise. These aren't mistakes. These are choices. Her eyes stayed locked on him. And those choices stripped lawful citizens of their rights. Silence followed. No one rushed to fill it. Judge Leon leaned back in his chair and studied both sides of the room. He looked at the scattered papers on the state's table. The nervous shifting. The whispered exchanges. Then he turned his gaze toward Crockett. His voice was quieter now, but heavier. You didn't just argue this case, he said slowly. You changed it. 3 weeks later, the ruling dropped like a thunderclap. Judge Leon issued a sweeping injunction that froze the voter ID law in its tracks. His opening lines were blunt, almost surgical. The policy, he wrote, was neutral on paper and discriminatory in practice, and the evidence of intent could not be ignored. Within minutes, phones across the courthouse lit up. News alerts flashed. Producers shouted into headsets. Reporters sprinted out the doors to break the story live. Outside, cameras swarmed the steps as the headlines spread across every major network. Civil rights groups erupted in celebration, while state officials went silent. Behind closed doors, lawmakers in other states began emergency meetings, scrambling to review their own voter laws before they became the next target. One governor's office leaked an internal memo calling the decision a legal earthquake. Advocacy organizations wasted no time. Lawsuits were filed in wave after wave, citing Leon's ruling as a blueprint. What had started as one courtroom battle was now reshaping the national map. The impact hit the ground fast. The blocked law forced the state to reopen DMV offices, extend hours, and create mobile ID units for rural communities. In the very first election after the ruling, turnout in previously restricted districts surged by more than 30%. Polling stations that once stood half empty were suddenly packed. Elderly voters arrived early, gripping paperwork like treasure. First-time voters stood in long lines without complaining, smiling instead, taking photos, calling family members. One woman wiped tears from her eyes as she dropped her ballot into the box and whispered, "They can't stop us anymore." Volunteers cheered quietly. Poll workers nodded to each other, stunned by the change. Across the country, similar scenes unfolded as other states adjusted their policies under growing legal pressure. The ripple effect was undeniable. One courtroom decision had shifted the balance of power. One hearing had forced lawmakers, courts, and governments to rethink the rules. As analysts debated the long-term consequences on national television, one line kept circulating online, shared millions of times in bold white text on black screens. A single courtroom rewrote the battlefield. 2 months later, Jasmine Crockett stood on a much different stage. No judge's bench, no hostile attorneys, just a packed auditorium filled with young lawyers, civil rights advocates, and people who had watched the courtroom battle unfold in real time. When she stepped up to the microphone, the applause was loud, long, and emotional. She waited for it to settle before speaking. "This case wasn't about winning," she said quietly. "It was about showing up prepared for people who don't always get a seat at the table." The room fell silent. She didn't brag. She didn't list her achievements. Instead, she talked about late nights reading documents, traveling to forgotten towns, listening to stories no one else wanted to hear. "The work that matters," she said, "happens long before anyone is watching." She paused and looked out at the crowd. Power isn't yelling louder than the other side. Power isn't having the biggest team or the flashiest resources. Real power is discipline. It's patience. It's walking into a room knowing the truth so well that no one can shake you. Some people nodded. Others wiped their eyes. The message landed because it felt real. It wasn't theory. It had been tested under pressure, in front of cameras, under the weight of public judgment. After the speech, a reporter asked her if the case had changed her life. Crockett smiled slightly. "It reminded me why I started," she said. "There are still millions of people whose rights are fragile. If I stop doing the work, the noise will take over again." She didn't stay long. No victory tour, no spotlight chasing. She left the stage the same way she had left the courtroom months earlier. Calm, focused, and ready for the next fight. And that was the real legacy of that day. Not the headlines, not the praise, but the proof that quiet preparation beats loud power. If this courtroom battle moved you, make sure to like this video and subscribe to the channel for more real stories where truth meets power. Drop a comment and tell us what you think. Should access to voting ever depend on money, distance, or paperwork? And stay tuned, because the next case we're covering features another high-stakes showdown where one voice steps into the courtroom and refuses to back down. Justice doesn't sleep, and neither do these battles.